All right, it's Thursday, December 3rd, 2020. As you know, at Thursday, 6:30, we do our weekly Facebook Live. We missed you last week for Thanksgiving. I hope everybody had a wonderful Thanksgiving and time with their family and their friends and were able to relax, eat good food, and get some much needed rest. We have a really great show for you today. It's great for two reasons. One, it's kind of a Meet the Team series. If you remember back in May, we were introducing members of the office. And this member is an attorney, and she joined us a few months ago and hasn't even been up on the website yet. So you guys are going to meet her for the very first time and hear all of her wonderful information she has regarding a very popular visa called the EB-2. And we're going to talk about very briefly those with job offers, but more importantly, the NIW, which is the National Interest Waiver. So before we get started, I just want to start with some good news, as we do in tradition here. And first, today we had a client at a USCIS interview. Attorney Joel Caminero was there, and actually it started off bad. Immigration USCIS wanted to issue him a notice to appear for the court because his spouse withdrew the petition. However, this was an error, as USCIS did not adjudicate the 751 application, and Attorney Joel was there and advocated on his behalf, spoke to two supervisors, and they promised him to cancel the NTA, which is a notice to appear to initiate removal proceedings. So that's our good news, and good job for Joel. The other good news is, like, I'm truly happy to have Attorney Natalie here with us today. She is just a really awesome person and very knowledgeable in employment-based visas. Some quick updates. There's not much. We're going to be watching what will happen with the immigration court. They announced a few days ago that they're going to resume hearings at the Orlando Immigration Court. However, we have received several cancellations, so it'll be interesting to see what's actually going to happen in the court. So if you are in immigration removal proceedings, please check your notice of hearings, check online, call the 1-800 number to verify whether or not your hearing is going to move forward. If you do not attend for a hearing, you will be ordered removed in absentia. It's super critical, so please make sure you pay attention. Orlando is operating now, so we'll see what has to come with that. As you all know, December 1st, few days ago, USCIS is now going to administer a new naturalization exam for those who are applying for citizenship. The exam will now be 20 questions long as opposed to 10, and it will be from a question bank instead of 100, 128. The new exam is up and the questions are up. So if you want to take a look and see at the new difficult, or some people are saying tricky questions, USCIS.gov will have those for you. Finally, we spoke about President-elect Biden and what his proposed changes are. And some really good for the Venezuelanos is that he has promised that temporary protected status will happen. Temporary protected status is basically allows those who are here and unable to return to their country due to unrest or catastrophe or disaster, the ability to work and live in the United States. Okay, so please remember to subscribe to our newsletter or YouTube channel and social media. This is going to be a very informative session. We receive calls on this visa weekly, and especially email inquiries for people from Brazil or international students from UCF. So we're going to talk about the EB-2 NIW. But first, let me tell you about attorney Nataly Mualem. She is a Syrian-born immigrant to the United States, but she came here when she was 5 years old. She has a bachelor's degree in chemistry, and she went to Ohio Northern Law School for her law degree. And she's been a practicing attorney for 3 years, and she joined our firm a few months ago. And we are happy and honored to have her join our firm. She loves what she does. She's super passionate about it. She has a focus on employment-based visas, which we'll talk about. A lot of times you guys, our audience believes that immigration is only naturalization, citizenship, or family-based petitions or deportation. There's a whole business and investor side of the immigration world that has employment-based visas where you need to have a job offer. And you're going to see just how complex it is, where your cousin or your brother just can't offer you a job and you get a green card. It absolutely does not work that way. And we're going to talk about what employment-based visas look like and in detail and focus on the EB-2 NIW. So without further ado, I'm going to bring on our wonderful guest. If you guys can help me welcome Attorney Nataly Mualem, please.
Hello.
Hey, Natalie. How are you?
Hello. Thank you so much for inviting me to speak with you today.
You're welcome. I've been asked. I think I asked you a couple times, but always I'm happy you're here or virtually here. I know you are in a snowy place right now, and we had our own cold front. Here, it was even down to the 40s, but we don't have any snow. So how's Ohio treating you?
It's going very well. Definitely a lot more snow and a lot more cold fronts than Tampa, but we're still doing well. Thank you.
So as I mentioned, Natalie's an attorney for the last 3 years. She's also has the hardest job of being a mom to her son and a wife to her husband, and they are going to be new residents, or they are new residents in Florida. So not only welcome her and her family to Mubarak Law, but welcome her to Florida as well. So there'll be no more shoveling snow. Natalie, what made you want to become an attorney? I know we're going to talk about this employment-based, but this will be your Meet the Team series, and I just want to know why did you decide to do law, and why did you decide to do immigration?
Sure. So I always wanted to be an attorney because I thought it's such a special thing to be able to advocate for people and to make sure that everybody's represented and gets a fair chance. It's actually been a childhood dream of mine to become an attorney, and I'm glad that I was able to fulfill that. And then more specifically, I entered into immigration because myself, I'm an immigrant, and my family are all immigrants. So I understand the importance of it and how much it has an effect on people's daily lives.
How would you say that most people's immigration story is affected by having a competent or strong attorney? In your experience, as you mentioned yourself, that you've gone through this process, and it's been, I know, a long journey for you. So how would you say an attorneys have been helpful or not helpful?
So I think it makes the world of difference. It's providing you with the right tools because on the other side, even though in many instances USCIS is not supposed to be adversary, it is. In nature, we see that a lot of times on the ground that they are. And in order to be well equipped and more than that, even just to understand the legal principles. So when you send forth a petition, having the right advocate there for you definitely takes away a lot of the issues that could occur. And the unfortunate thing about immigration is it's very unforgiving. So anytime a mistake has been made, whether it's by an attorney or by an individual, it's very difficult to correct that mistake. And a lot of times things that haven't been caught on early on end up creating years of issues and backlog for the foreign national, while if they were represented correctly from the beginning, they could have had a smooth transition and became lawful permanent residents and citizens in a lot quicker way.
I think you hit the nail on the head with the unforgivingness of immigration, and people don't realize by signing these forms, you are basically making a sworn statement. And if there's any information, whether or not you completed it or not, by signing these forms, you are presenting this as factual information, and people don't realize sometimes the consequences that they can have on their case and in their future. So you focus on employment-based immigration. And for those who are joining us, as I mentioned earlier, there's more to immigration besides deportations and family and citizenship. There's an employment-based aspect. And we have several categories: EB-1, EB-2, EB-3, there's the EB-5. And we're going to discuss today the employment-based visa. So I'm going to have Natalie tell us, what is the EB-2 visa and what types are there, if you can walk us through that.
Sure, of course. So the EB-2 visa is a type of immigrant visa. And what that means is that the person, when they apply for this petition, they have the intent to permanently resettle in the United States and become a permanent resident, therefore get their green card. It's different than H-1B visas, for example, which are temporary and they're non-immigrant. So this is for people who intend to live here. And then within the EB-2 visa category, there are two subcategories. Those are advanced degree and exceptional ability. So that you have to fit into one of those subcategories to get your foot in the door, to, you know, in other words, to get into that EB-2 visa category.
Okay.
And then,
I know we are going to talk about national interest waiver, which is one of the categories, but or exceptional ability, excuse me. But for the EB-2, is a job offer required? Because a lot of times clients come to our office. Can you help me find a job? Or I don't have a job offer. Is the EB-2 one that people can pursue without a job offer?
In most instances, no. The typical EB-2 visa requires two things. That's a permanent job offer and then a labor certification. So a permanent job offer means that it's something that you and your employer don't have a contemplated end date, and it's not based on any other external factor. And then the other portion of that is the labor certification, which what that is basically is employers are required to test the labor market. So they typically have to place ads, most famously 2 Sunday ads, but they also have to do other forms of advertising as well, in order to see if they're qualified U.S. workers, which means people with either U.S. citizenship or a green card. And if there are, then the employer is basically forbidden from then sponsoring an immigrant, because the whole idea is that the Labor Department is supposed to protect the interest of American workers first, and then in areas where there are deficiencies, then we can supplement that with foreign nationals. And it's usually a cumbersome process that takes several months to achieve. So that's the general EB-2 category with those two requirements, again, requiring both the permanent job offer and the labor certification.
Thank you. And I want to make a little comment here. You mentioned that we have to test the labor market. So this basically means that the employer has to put a job placement. We have to see if we can find a U.S. citizen, a resident, somebody already here with the ability to work to fill this position. So this notion from certain politicians that we are forcing the loss of American jobs is simply not true. Right? You have to advertise the position. You have to demonstrate the process. And a lot of times it can take several months. A lot of employment-based cases, going through the perm process, we tell our clients, expect anywhere from a year to 2 years. And the employers are usually shocked. Well, I need somebody now, but how am I going to run my business without this particular individual? So, okay, so then they advertise the job, Department of Labor certifies the position. What happens next?
So the next part after the certification would be the employer then must file a form I-140, which is the immigrant petition. And then depending on whether that's done concurrently or if the person's outside the United States or there's other circumstances, they might also then do the adjustment of status I-485 form. The I-140 basically confirms the job offer, confirms the details, and matches all the details to the certified labor certification. So, so that basically qualifies the job, and then also tests the requirements of that job against the individual's work experience. And then the next step would be the adjustment of status, which then just looks to see whether this individual is admissible as an alien to the United States.
And some things that make somebody not admissible is going to be like criminal history or negative immigration history, for example. So you can see why it's a lengthy process, and you have to basically prove, that you are eligible for this job. You have the experience. It fits. We can't have somebody from abroad with a civil engineering degree apply to be a chef. And a lot of times it doesn't work that way. You need to demonstrate your ability. So let's come into the requirements of the EB-2 specifically. You mentioned advanced degree. Can you please tell our audience and those who may be watching this later, what is considered an advanced degree for USCIS and this EB-2 category?
Sure. So an advanced degree is a master's degree, a PhD, or their equivalent, which sometimes could include a bachelor's degree and then the requisite years of experience. So that depends on the field and what evaluations you're able to get to say that, you know, your 10 years experience in one field might make it equal to a master as well. In some fields that are more specific, that length of time could be less.
Yeah, so you might not even actually have a degree, right? But if somebody has 20 or 30 years experience in a very particular field, we may be able to contact a company like Morningside, for example, and get an equivalent where they'll say, you know, your work experience with this kind of company is equal to a bachelor's degree or it's equal to a master's degree. So it's, you know, it's really important when we have consultations that our potential clients put together a very detailed CV, and then they know that this is not going to be a yes or no after our first meeting. These require in-depth analysis. So if you don't have an advanced degree, are you out of luck for the EB-2 NIW?
No, definitely not. The other way to get into that category is through exceptional ability. And the way that's demonstrated is with a variety of tests. So they look at it more holistically, and they look at the requirements of the typical entry-level positions, as well as the requirements of more advanced positions and how this person falls within that scope. So for example, it's all relative. So for example, things that they look at is, does this person have the degree that's typically required to enter this field? So for example, if you're a civil engineer, in most cases you need a civil engineering degree. They also look at the length of experience. So if somebody has more than 10 years of experience, that's seen as a positive factor. They look at whether a person holds a license to their profession. So obviously both me and you have bar licenses, and we're licensed in our states because that's a requirement of our degree. And in many instances, that's the same for a lot of different people. All the other things that are looked into is whether somebody is commanding high salary, because USCIS views capitalism as kind of understanding the requirements within that field or that industry. So if somebody is getting paid $400,000 while their equivalent is getting paid $100,000, USCIS will then give the benefit of the doubt to consumerism and capitalism and say that the reason that this person has a high salary is that they have this intrinsic skill that might be, you know, that they possess, or very select people possess. The other thing to look into would be membership in a professional organization, especially memberships in organizations that require strict criteria. There's also obviously recognition by peers, government institutes, professional organizations, things like that, that also are considered favorably. And then you're also able to present any other forms of comparable evidence. So obviously there's some fields where things aren't as cut and dry, or the field itself is not as defined. So you could submit other comparable evidence. And then out of these criteria, typically USCIS will look for at least 3 in order for somebody to be considered to have exceptional ability.
Okay, so you know, if you're receiving a higher salary, if there's been awards or publications, these are things that we look at when we're trying to do this determination whether somebody may be eligible under the exceptional ability category. And you know, some clients are very humble, and they don't share all their incredible awards. And some clients, you know, present things that, you know, they worked really hard for, but unfortunately under USCIS, it doesn't meet the exceptional ability requirement. If you're a member of an engineering society, but that engineering society accepts everybody for paying a $50 application fee, then there's nothing special about it. But if that society is only admitted to those who are voted in, like there's a panel, you have to be accepted, you have to demonstrate, and there's this very, you know, exclusive, then that's something that we can use in the future or for your case to support your exceptional ability. So this visa, what I want to get to is the EB-2 National Interest Waiver is very popular. right? And people call us all the time about this. What do you think is the main reason why people find this this option particularly attractive? And then after that, if you could tell me what the national interest waiver is. But before you do, we do have some comments. Let me see. Well, Dexter King, a good friend, congratulations. Thank you. And then we have Hamad here. Thank you so much. I appreciate that. Natalie كمان بتتكلم عربي. So إذا عندكم أي سؤال معاها تفضلوا اسألونا أي سؤال وناتالي راح تساعدنا بال أي شيء بدكم إياه. So thank you. So why do you think some of these people our applicants are very interested in this particular visa, the national interest waiver portion?
So I think there are multiple benefits to this visa, and it's definitely very attractive for different reasons. The first of which is, since we don't have to go through the labor certification process, it makes it a lot faster. And if a person is granted the national interest waiver and obviously applies for adjustment of status, they will get their green card. And typically the processing time for this visa is between 3 and 9 months, which is significantly shorter than the typical EB-2 category. And then I think the other portion of it, which is probably more practical other than just saving time, is that as the outlook towards immigration has changed, a lot of employers are more hesitant to sponsor people, and you have to have a job offer in hand and a willing employer to sponsor you before you're able to do many other categories. So this one gives people the power to self-petition, and I think that's very important, because in a lot of cases it's just not practical, or it's not feasible for the employer to do it, or they're just not willing to because they have their own reservations about how this process is going to be or the time that it takes. So this gives people the ability then to just self-petition in many instances, and gives them the ability to continue their work without having a firm permanent job offer.
Right. So for those who call or come see us for a consultation and say, can you help me find a job? Do you know anybody who's hiring, or how do I get this visa? This kind of resolves that for them, because you are basically saying that what you can provide to the United States is worthy of being forgiven for not having this job offer. So let's talk about this some more. You know, they meet the exceptional ability. They have the national interest waiver. They want to try it. What do we need elements or items to demonstrate in order to qualify for the national interest waiver?
Sure. So first, before looking at the applicant, USCIS will look at the proposed endeavor. What is this applicant planning to do once they get their immigrant visa? And that endeavor has to have both substantial merit and national importance. And this has changed a little bit since 2016, because it's become a little bit less difficult for foreign nationals to be able to meet this burden. So substantial merit basically means something that intrinsically helps the United States. So we look at things most obviously like cancer research, for example, or any sort of medical or science research. That's something that's helping the United States. But also more recently, it includes things that are also culturally enriching or artistically enriching. So if you're able to provide services that enrich people's understanding of different cultures, or people's understanding of art, or just artistic expression, that could also qualify as a national interest. And what we look at is to see one of the ways to prove this is to see if there is a federal agency that's tasked with solving this issue. But there's also other ways to demonstrate this, including looking at data, statistics, what's actually needed in the United States, different initiatives that nonprofits have, and looking at where there are needs. And then the other portion of that is national importance. So it has to be just as important in Florida as it is in Ohio, as it is in California. Basically, from sea to shining sea, it has to have national importance. But what this does not mean is it no longer requires national scope. That means you don't have to have an operation or an endeavor in every state. It just has to matter. So, for example, if you're working for the Mayo Clinic and putting forward, significant cancer research, even though you're working in one location, the significance of this research is widespread throughout the United States, and that would qualify.
Sure.
But in instances that wouldn't work is even if you have, like, for example, a really good academic program that you've developed, but you only use the academic program in one school district, then, that is substantial merit because we want our students to be educated and, to have all the best resources. But since it's not being applied nationally or even has that national importance, then that might not qualify for this first prong.
Okay, so we mentioned a couple of things. We talked about cancer research, right? Or Mayo clinics, and what if somebody is not this scientist or this physicist? Like, can somebody who's an artist, or can somebody who is a mathematician or an engineer, do these people have a chance to meet the national interest waiver requirements?
Most definitely. I think that it's not, a cancer researcher is probably the easiest example to give because, no two people are going to argue that it's not important, but there's definitely
a wonderful case that it was just like approved. She was extremely, like, couple PhDs, couple master's degrees, and she was working on very high research for cancer. So thankfully, hopefully that's not just going to benefit the United States, but maybe the whole world. But how do you think other people might be able to come up with this requirement?
So, there's plenty of resources. So, for example, going back to our earlier example of civil engineers, if you're able to develop a material that's, going to be used in bridges all across the country, or if you work in oil refinery and you're able to come up with a technique that's going to make fuel more efficient, or if you're able to come up with different ideas for administrating medication, or doing even among the arts, there's cultural enrichment. So, for example, Australian Aboriginals might not be really represented in television. And if you're coming up with a production company and you focus on that group of individuals, then that might be of national importance because you're providing this this new outlook that people didn't have before, and you're culturally enriching. And there's also obviously importance in psychology, psychiatry. There's social work that could all qualify under this first prong in this first category.
So how does somebody prove that they're going to do this, right? I know, but do they go and do they talk in front of somebody? Hey, this is my presentation. This is how I'm going to do it. Well, how can we demonstrate to USCIS that that they are doing something that's of substantial merit, national importance? And then this next prong that I put up, individual must be well positioned to further this endeavor. How can we prove this?
Sure. So the way that we prove this is basically we got to take a step back and look at who USCIS typically is. And it's people without these backgrounds. They don't have scientific backgrounds. They don't have backgrounds in these, different things that we could apply for. So what we rely on are different advisory pieces of evidence that we put forward. So these include reference letters, publications written about the individual, news about the applicant that that's published in major circulation, things like that. Or you can even get different evaluation of their work from their peers or professional associations or organizations that talk about the importance of their specific work. And then going to the second prong, that the individual is well positioned to further the endeavor. What we look at forth here is, does this person have the right tools in their toolbox in order to be able to do this? There's no requirement that says, you have to prove with 100% certainty that if you do get this visa, you're able to further this. Like, for example, in the cancer research, they're not going to require this person cure cancer, even though that's the goal that they have. But in order to further that endeavor, they have to have the right tools in their toolbox.
If you say you're going to present a new system or jobs or a new studio or something, a new industry that's in need here, you have to show that you can do it, right? So oftentimes we do this with a business plan. We show reports, we have financials to show that this individual is not just talking fluff. They'll have the ability to do what they're going to say and basically execute what they're saying they will execute. And so that's really important. Part of it is, and a lot of times the clients don't even, sometimes know specifically what is their endeavor specifically. So you need to figure out what it is you do. The advanced degree and the awards are not enough. What is it that you're going to do to benefit the United States?
And I think that's where like competent counsel also comes in. Sometimes, we work with the client on defining it. They might do something very broad, but only, in a narrow sense that their work qualifies under this category. So we help them either fine tune that or to define it better. And we sit down and talk with a client in order to perfect this. And, they having a proven track record is also something very favorable to prove the second criteria. If you have been able to develop a vaccine in the past, you're more likely to be able to develop a new vaccine. For example, like if we're talking about obviously something on everybody's mind, which is COVID right now. If somebody was to apply for an NIW based on COVID research, well, if they had worked on H1N1 and have been able to provide successful results, then that's something that we can definitely use to prove that second prong.
The church bells are telling me that we're at 30 minutes, but we're going to talk a little bit more because we haven't hit all of the requirements just yet. And I want to talk about benefits too. So if I can just have 5 more minutes of your time, Natalie. And so tell me, what about this one?
So after we prove the first and second prong, we also have to then prove to USCIS that it would be in the national interest on balance to waive the labor certification. So USCIS says, wow, great. You are trying to do really great work and we think that you can do it, but why don't you just go through the labor certification process like everybody else? So there are several instances in where this is not required, or it would be, not the national interest to do. The first one would be it's impractical to secure a job offer, or that it's impractical for the petitioner to obtain a labor certification. So one example of this is for postdocs. A lot of postdocs work and they have grants, but these grants aren't, they're not promised, basically. They're grants from different organizations and they're not promised. So they can't have that permanent job offer that's required for the labor certification. So in an instance like that, they're obviously benefiting the United States, but they can't obtain that. Or in other instances, the type of work they do, like if it's artistic work, it would be too difficult to define that, because in order to test the labor market, you have to have a list of requirements. But how do you require somebody's experience and past and vision and work? It's very difficult to put down on paper and do. So, if it's impractical to do, that's one of the options. And then the other option would be that even if there are qualified U.S. workers, the U.S. would still benefit from this person. So sometimes the more the merrier. If there's a big issue facing us, even if there are other U.S. qualified workers, the United States will still need more. And this person might have their own unique take on the issue or their own unique perspective that the United States will still benefit from. And then the third way to achieve this would be that the national interest is very urgent. So, pandemic, for example, might be considered urgent.
Well, that's a great way to show we need somebody here now to work on this. This was a lot of information for everybody. And as I always do, I beg you to subscribe to our YouTube channel, and then you can watch it or share it with anybody who may be interested or who you think may qualify. So if you think somebody who has a special skill, or they have an advanced degree and they want to reside in the US, maybe this option is for them. So now let's say I'm approved for the EB-2 NIW. I have family and children. Who's allowed to come with me when the case is approved?
So this is a great question. As soon as your case is approved, your spouse, as well as all minor children, would be able to come with you immediately. They would be included in the adjustment of status application, and then be able to receive their own green cards immediately with you.
Okay, so this is good for the family and any children under age of 21 that are not married, and they'll be able to come. So, Natalie, anything else you want to add before we sign off? I know this is just like the tip of the iceberg for this these types of cases and for employment-based cases. Anything else you want to share?
I just want to say that the national interest waiver is a very viable option. It's a very good option. And I think that anybody who thinks that they qualify for this option should really, contact an attorney and discuss this with them, because we've had a lot of success stories when the person initially didn't think that, they would be able to successfully obtain this. And, if this case is approved, then, it's a fast track way of getting a green card and having your whole family immigrate here quickly and successfully.
Okay, so welcome again, Attorney Nataly Mualem. Ahlan sahlan fiki. Option, wonderful person to join our firm, and I'm happy that you're here for our clients too. So if you have any questions about the EB-2 NIW, you can, as I mentioned, follow us on social media for more updates and information on it, or you can contact our office for a consultation. Put together your documents, your resume, and your CV. We will not be here next Thursday for Facebook Live. I am the regional chair for the American Immigration Lawyers Association, so I do have an obligation to have the end of the year meeting and get together. So that's where I'll be next Thursday. But hopefully the following Thursday will be our last Facebook Live of 2020, and we will continue this tradition that has come up from going virtual, and regardless of what happens in the future, we will continue to bring information and positivity to you all. So if you have any questions for us or any topics you're interested in hearing more about, please contact us, and we hope to continue to serve you all.
Thank you so much for having me on.
It's always my pleasure, Natalie. Thanks, guys. You guys have a great night, and thanks for joining us.